It could work. It's the most mind-blowing way to legalize that sweet Chiba. Let's talk about the craziest ways our country could legalize that sweet sticky green herb. I know our robot overlords are looking down on us, laughing their robot asses off right now at our government because they see a bunch of old octogenarians stuck in the Stone Age, struggling to use their own phones. These same politicians ignore the fact that over 70% of the American people support legalizing it. Go figure. Maybe all of this is some non-progress type of exercise that we are welcoming the next species of alien invaders to take over human civilization because you really don't have to worry about their mental acuity. Nah, it's way more twisted than that. The most mind-blowing way weed could actually get legalized has already happened before. I was just reading about it. It could work. In this video, I'm going to show you how cannabis legalization may actually play out in the next couple of years in the good old US of A. And stick around for something you may not have been expecting from us at all. As you might already know, this whole mess started way back before the Marijuana Tax Act of 1937, where the federal government required individuals to register and pay a tax on marijuana. Congress made the law so that you needed the marijuana to pay the tax, but if you paid the tax, you got reported to your local authorities. A real heads-I-win, tails you go to jail type of thing. 32 years later, in 1969, the Supreme Court unanimously ruled that the first federal law on cannabis violates your Fifth Amendment right against self-incrimination. Can you imagine that? The Supreme Court legalized it before most of all of you were even born. Timothy Leary was involved. Maybe acid was involved. I don't know. I was not there. Now let's fast forward to 2005, the most recent Supreme Court decision about the federal law actually being constitutional. That's when it was handed down. But there was a comment back in 2021 that makes us really think that what happened back in 1969 could happen again, meaning it's possible for the Supreme Court to legalize it again. In 2005, the Supreme Court voted 5-4 to keep cannabis prohibition on the books in the Gonzalez, who was the Attorney General at the time, versus Raich, who was a California medical marijuana patient. In this case, Congress wanted a uniform federal prohibition, but the times sure have changed in the past 18 years. In 2021, the Supreme Court declined to hear a case called the Standing Akimbo LLC case. It was a non-case because the Supreme Court said they did not want to hear it. They aren't going to upset federal law. At least it was a non-case because the court didn't want to take it and examine whether the IRC 280E double taxation that only applies to the cannabis industry was constitutional. The court said, no thanks. But Justice Clarance Thomas issued a statement after the court left the tax in place to question whether the federal cannabis laws are constitutional anymore. He reasons that the federal government allows states to act as the laboratories of democracy and try novel social and economic experiments. And in this, he cited O'Connor's Raich dissent when he wrote that the federal government may no longer have the authority to intrude on the state's core police powers, to define criminal law, and to protect the health, safety, and welfare of their own citizens. A prohibition on interstate use or cultivation of marijuana may no longer be necessary or proper to support the federal government's piecemeal approach to the cannabis plant. And the most mind-blowing thing about this method toward cannabis legalization is this: Justice Clarance Thomas is right. His full statement on this case should give confidence to NORML or any other organization that wants to file a lawsuit to invalidate the Schedule I status of THC. Now, let's break down what Justice Thomas said in his statement on Standing Akimbo. Remember, in 2005, the Supreme Court most recently held, which is just a fancy legal way of saying what the court said, that Schedule I THC is constitutional because it is within Congress's power to regulate interstate commerce and authorize it to prohibit the local cultivation and use of marijuana to regulate the federal market of marijuana. Thomas continues to explain that the reason, according to the court, was that Congress had enacted comprehensive legislation to regulate the interstate market in a fungible commodity, and that exemptions for local use could undermine this comprehensive regime. No, seriously, you can read this case. The citation is in the description down there. But here's what Justice Thomas's comment says. The court stressed that the Congress had decided to prohibit entirely the possession or use of marijuana and has designated marijuana as a contraband for any purpose. Now, that was true when it was written back in 2005, but not so much right now in 2023. Think how much has changed since then. In 2005, 0 adult use states. In 2023, 23 adult use states. In 2005, 10 medical marijuana states. In 2023, 38 states and D.C. Back in 2005, federal cannabis policy was a comprehensive no. According to Justice Thomas in his statement from the Standing Akimbo versus United States case, which is a funny name, Akimbo, but here is some of his commentary from 2021. In that case, where he writes that the federal government's current approach is a half-in, half-out regime that simultaneously tolerates and forbids state and local use of marijuana. This contradictory and unstable state of affairs strains basic principles of federalism and conceals traps for the unwary. The strain on federalism principles gets to the conflict between the state and the federal law. It's about operating a medical marijuana dispensary in Colorado as state law permits, but yet federal law still flatly forbids possession, cultivation, or distribution of marijuana. Specifically, these laws do. The Controlled Substances Act, 84 Statute 1242. Also 1247, also 1260, also 1264. And don't forget 21 USC, Section 802, Paren 22, and also 812 Paren C, and also 841 Paren A, and also 844 Paren A1. Those aren't all of the federal crimes. We'll get to more soon. The federal government, post-Rage, has sent mixed signals on its views, increasingly brazen toward full legalization in a piecemeal fashion. For example, in 2009 and 2013, the Department of Justice issued memoranda outlining a policy against intruding on state legalization schemes or prosecuting certain individuals who comply with state law. In 2009, Congress allowed Washington, D.C.'s government to decriminalize and then later legalize medical marijuana under local ordinance. In 2014, the Department of Treasury's Financial Crime Enforcement Network, FinCEN, issued guidance on how to have non-suspicious activity reports for state-compliant cannabis businesses at federally insured banks and credit unions. Moreover, in every fiscal year since 2015, Congress has prohibited the Department of Justice from spending funds to prevent states' implementation of their own medical marijuana laws. Also, in 2016, in the case of United States versus McIntosh, interpreting the rider to prevent the spending by Department of Justice, it became a defense the prosecution from the Department of Justice unless they had an evidentiary hearing that showed your behavior was out of compliance with state law and therefore there's any money, prosecute your ass under federal law. If all this sounds pretty crazy, actually in law, we call this stuff arbitrary. If you had asked me this, I would say, yeah, that makes no sense. It's illegal unless this, or unless that, or unless that. And this policy has broad ramifications, given that 38 states allow medical marijuana use and 23 of those states allow full adult recreational use as of August 23, with Ohio and Florida close at hand. And perhaps your state, given all these developments, you could hopefully understand why an ordinary person might think the federal government has retreated from its once absolute ban on marijuana, like back in 2005. Cannabis business owners like us think that our intrastate marijuana operations will be treated like any other enterprise that is legal under state law. Yet, legality under state law and absence of federal criminal enforcement do not ensure equal treatment. We are talking about a provision of the tax code that allows most businesses to calculate their taxable income by subtracting from their gross revenues the cost of goods sold and also ordinary and necessary business expenses such as rent, employee salaries, and others. But because of public policy provision in the tax code from 1981, companies that deal in Schedule 1 or Schedule 2 controlled substances prohibited by federal law may subtract only the cost of goods sold and not the other ordinary and necessary expenses. For more on that, see Internal Revenue Code, Section 288. Under this rule, a business that is in the red after it pays its workers and keeps the lights on might nonetheless owe substantial federal income tax. In other words, state-licensed cannabis dispensaries have found that the federal government's willingness to often look the other way on marijuana is more episodic than it is coherent. This disjuncture between the government's recent laissez-faire policies on marijuana and the actual operation of specific laws is not limited to the tax context. Many marijuana-related businesses operate entirely in cash because federal law prohibits certain financial institutions from knowingly accepting deposits or providing other bank services to businesses that violate federal law. Cash-based operations are understandably enticing to burglars and robbers. But if marijuana-related businesses, in recognition of this, hire armed guards for protection, the owners and the guards might run afoul of a federal law that imposes harsh penalties for a firearm in furtherance of a drug trafficking crime. A marijuana user can similarly find him or herself a federal felon if he or she possesses a firearm. Plus, state-licensed marijuana businesses may find themselves on the wrong side of a civil suit under the Racketeering, Influence, and Corruption Organizations Act, better known as the RICO Act. Suffice to say, there is no other law in the United States that requires a complicated flowchart to determine whether you need to worry about the crime you are committing or not. So I believe that the federal marijuana laws related to cannabis are unconstitutional because they are outright insane, and therefore they violate the rational basis test of constitutionality. It makes no sense to maintain a federal policy that encourages cannabis banking and medical marijuana operations while simultaneously imposing penalties and taxes because of the Schedule I substance. Such an insane approach would deem all transactions akin to money laundering, even in cases where medical use, where law enforcement is waived. This contradicts the classification as a Schedule I substance. In this category, they are deemed to have no recognized medical value at all. The government just can't say one thing, then have its policies treated as if it is completely different, especially when the law says that any possession or use is a crime. Now that you know that the laws are already selectively enforced, think about if safe banking passes further along into the arbitrary federal laws, or if the Department of Justice ban and enforcement goes from medical to all state legal adult use. Then it's even more arbitrary. How long does it have to go before it is unconstitutional because the Supreme Court says there is no reasonable or rational basis for the Schedule I classification of marijuana, considering everything that has happened since 2005? If you want more of this content, tune in to our live podcast on Sundays. Click subscribe, leave us a comment as it greatly helps grow the channel so that you can help legalize it.